Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about a derivative action brought in respect of a trust. Now, we often speak about derivative actions brought pursuant to Section 236 or 237 of the Corporations Act, and the Corporations Act, the clue is in the title, tends to deal with derivative actions relating to companies. So we don't often deal with derivative actions relating to trusts. So today we're dealing with an interesting trust that has substantial assets in it. The trustee is a company. The shareholders in the company are 2 kids out of a family including 4 kids. The trust was set up by one parent who is no longer involved, and the principal beneficiaries of the trust are these 4 kids and the spouse of the spouse who set up the trust. 5 principal beneficiaries, this spouse and the 4 kids. The trustee, the shareholders of the trustee are 2 of the 4 kids, and the defendants in this matter include 2 of the 4 kids. Now, the nature of this trust is that it has substantial assets, as I mentioned earlier, and those assets include real estate. And broadly speaking, the dispute we're talking about today is one of our kids suing the 2 of the other kids and the trustee. Why? What our plaintiff kid over here is complaining about today is the way this trust has been managed. And the plaintiff kid has a number of complaints. Now, one of the complaints revolves around the distribution of income in relation to the trust. Now, the trust deed is quite complex, but the trust deed includes terms that say that if there have been no valid resolutions passed, then the income of the trust ought to be distributed amongst these 5 beneficiaries. And what our plaintiff kid says today is, look, there were no valid resolutions in relation to the distribution of income because these 2 kids caused the trustee, remembering that these 2 kids are the shareholders and the trustee, caused the trustee to distribute the income to other entities relating to these 2 kids. And so what the plaintiff says is that this is a big concern of theirs, and that's one of the issues the plaintiff is complaining about today. Another of the issues that the plaintiff is complaining about today is that these 2 kids, in their control of the trustee company, caused the trustee company to transfer its valuable crane company out of the hands of the trustee and into the hands of another entity related to these 2 kids who are directors of the trustee. So the plaintiff has concerns about that. The plaintiff also has concerns about the payment of some money obtained from a compulsory acquisition. So the trustee owns some valuable land. That valuable land is the subject of a compulsory acquisition for about $58 million. And what these 2 brothers cause the trustee to do is they amend the deed, or they purport to amend the trust deed to allow them to distribute 44% of this $58 million to themselves each. So that's 88% gone, and 3% to our plaintiff kid, and the rest in dribs and drabs elsewhere. And so our plaintiff today is complaining about all of this conduct. And the nature of the complaint includes that there's been a breach of the terms of the trust deed in relation to these resolutions being a breach of the substratum of the trust, and a breach of the term I referred to earlier about the distribution of income going to the principal beneficiaries in the absence of a validly passed income resolution. And they say, look, there could not have been a validly passed income resolution in circumstances where it wasn't really fair for the distributions to go to these entities related to these 2 kids. Now, the nature of the relief that Plaintiff Kid is seeking is fairly extensive. So Plaintiff Kid is trying to bring this claim to say, I want equitable compensation, I want to remove the trustee, I want money to be paid back into the trust, I want some money to be paid to me, all these sorts of claims, prayers for relief. Now the challenge today gets back to that derivative action point we made. Some of those areas of relief, such as trying to get the money paid back from these entities relating to our 2 defendant kids, that's not a claim of Plaintiff Kid, that's a claim of the trusts. Does that make sense? Plaintiff Kid is just a beneficiary of a trust, and the trust has the claim to get that money back. The trust isn't going to make that claim because the 2 defendant kids control the trustee, And so the plaintiff is seeking to bring a derivative action to stand in the shoes of the trustee company, essentially to bring that claim on behalf of the trustee company. Now, as we all know, Section 236, subsection 2 of the Corporations Act abolishes common law rights to bring a derivative action. And so initially, our defendant kids say, the right to bring a derivative action on behalf of a trust is a common law right, and so you're prevented from bringing that. Now the court has to crunch through the issue relating here of, hang on, did the legislation abolish the right for a beneficiary to stand in the shoes of a trustee in order to bring a claim on behalf of the trust? Well, what the court found after going into some fairly deep analysis was no. The right of a beneficiary to bring a derivative action on behalf of a trust is a right that arises pursuant to the court's inherent jurisdiction to make orders about the administration of trusts. Put another way, it's not a common law right that was abolished by Section 236, subsection 2. It's a right that the court is able to make orders in relation to. So a court can say, yes, you beneficiary, in this case plaintiff kid, can have leave to stand in the shoes of the trust in order to pursue these parties that these misbehaving defendant kids have caused money to be paid to. So the court found, yes, there is a possibility that orders of that kind can be made. Yes, leave to bring a derivative action in the name of or in the place of a trust or trustee is possible. That can happen. What happened here was essentially the judge said, yes, that's possible, and I'm going to set down the hearing for when we're going to have an argument about whether or not you should get leave another day. But importantly, before the judge granted, set down the date for the hearing of the motion to potentially have the derivative action brought or to have leave for the derivative action determined, the court said, look, there are a number of challenges with this statement of claim. If you're seeking equitable compensation, plaintiff kid, that essentially means you're seeking money to be paid to you. But in this circumstance, we're talking mainly about derivative actions of the trust, where we want money paid from these third parties into the trust. So currently your statement of claim makes these complaints about all this conduct and suggests some money should be paid to you and some money should be paid into the trust. And it's not quite clear what should happen there and whether indeed there should be a bare trust where the trustee will hold some of the monies paid in on a different basis as trustee for the other principal beneficiaries of the trust. So there are pleading complexities that I hope I've just made a little bit clearer there for you. But in essence, the court highlights these pleading complexities, says yes, it is possible for a beneficiary to bring a derivative action on behalf of a trust, and says we'll hear the dispute about whether in this case this particular plaintiff beneficiary is granted leave another day. I hope that discussion assisted you in understanding whether a beneficiary can bring a derivative action on behalf of a trust. They can, and I look forward to joining you again soon for another coffee and another case note. Cheers.